What is the legal consequences of the unregistered sale agreement? Supposing you made a sale agreement without any registration, whether such type of sale agreement is valid in law, whether such type of sale agreement is admissible in evidence in the court of law, whether the registered sale agreement is advisable to a buyer or unregistered sale agreement is advisable to a buyer. As far as the seller is concerned, which is advantageous one, whether the seller should prefer registered sale agreement or unregistered sale agreement. Let us discuss all this question. Ladies and gentlemen, I am Raziaq. Let us discuss all these things in this video. You know very well what is meant by sale agreement and what is meant by sale deed. As far as the sale deed is concerned, it is a document through which the property is sold, property is transferred. So as far as the sale deed is concerned, once the seller receives the entire sale consideration, he goes to the register office and execute a sale deed and hand over the property and also all the documents through which the entire sale is completed and the property transferred from the seller to the buyer. This is the document called, this type of document is called sale deed. As far as the sale agreement is concerned, it is a document made prior to the sale deed. So normally when a person goes to purchase a property, they have to pay a huge amount and they have to verify the title and they have to check up all the procedure. They have to purchase stamp paper. So before investing a huge money, normally the buyer make some small payment as advance and make one side agreement through which he will agree to purchase the property. So this type of agreement through which a person agrees to purchase a property is called sale agreement. So sale agreement is nothing but an agreement prior to the sale deed. So initially the sale, as far as the sale deed is concerned, the registration is compulsory. Whenever the value of the property, as per the TP Act, whenever the value of the immovable property is more than 100 rupees, every such sale should be done only through a registered instrument. Registration of the sale deed is a must. So without a registered sale deed, a property cannot be transferred. So there is a law. As far as the sale agreement is concerned, previously the registration was not a compulsory one. It was an optional one. So at that time, the parties have a liberty either to go for registration or they need not go for registration of the sale agreement. So once has the law stipulated that the registration of the sale agreement is compulsory, now if the registration is not done, then such type of agreement and such type of unregistered sale agreement is not admissible in the court of law. The consequence is that supposing you make a sale agreement and pay some amount and the purchaser fails to pay the balance sale price, or the seller refuses to execute the sale deed, then if you go to the court and produce this document as this sale agreement, the court may not admit this document because it is an unadmissible document. It is not admissible in law because of the lack of one of the important elements, the registration. So without registration, this type of sale agreement, unregistered sale agreement, is not an admissible document in the court of law. So the consequence is that you cannot take this document and you cannot mark this document, and you cannot produce this document, through which you cannot make any substantial right over the issue. So in spite of that, most of the people are going for unregistered sale agreement, because if you go for a registration of sale agreement, there are some practical difficulties. In most of the sales transaction, the parties may agree to purchase or sell the property for a higher price, but when they go for a registration, they will make or they will quote a lesser price. So the price which is quoted in the sale deed is called white money, and the amount in excess of that white money is called black money. So white and black will be involved in most of these sale transactions. So in sale, in the registration of sale, there are possibilities that you can make white money and black money. But as far as the sale agreement is concerned, you cannot do that. Supposing you wanted to sell the property for 1.5 crores, and the agreement is made for 1 crore, and the black money is not paid at the time of sale deed, and the purchaser cleverly files a suit saying that I have made an agreement only for 1 crore, and the seller is not coming forward to make a sale deed, or he refuses to execute a sale deed, then he may deposit the 1 crore rupees in the court and get a sale deed in his favor, through which the seller will have to lose the black portion of the amount, black money. So as far as the sale agreement is concerned, you have to mention the real amount. Otherwise, the party will have to face a lot of consequences, whether it's a buyer or the seller. So normally, what as far as the purchaser, as far as seller is concerned, they don't want to take a risk. So to avoid the risk, they are insisting that we don't want to go for a sale agreement. We will directly go to sale. We have to go and execute a sale deed. You let you pay the entire money in one shot. Whether you want to pay over a portion as a black money or white money, let you pay the entire money in one shot, and I will register the sale deed, through which I can secure my interest, like what the seller is insisting in this on these days. As far as the purchaser is concerned, the registration of the sale agreement is an advantageous one. So if you have a registered sale agreement, the seller cannot sell the property to any other person. Supposing the purchaser entered a sale agreement and the seller do not come forward to execute the sale deed, and he tries to sell the property to another person, and if you approach the registrar, then registrar will not register a sale deed in favor of that party during the subsistence of the valid sale agreement or registered sale agreement. So whenever a party approaches to the registrar for registration of the sale deed, the registrar will ask for an encumbrance certificate. The encumbrance certificate will show the registration of the sale agreement. When there is a sale agreement, the sub-registrar will direct the parties either to cancel the sale agreement or to get a proper court order for the cancellation of the sale agreement. Then only he will permit you to execute a sale deed. So, as far as the purchaser is concerned, registration of the sale agreement is advantageous one. So he can restrain the seller from selling the property to any other party. And whenever the seller refuses to make any sale agreement, he can directly go to the court and file that registered sale agreement and get an order. He can simply file the suit for specific performance of the contract, and he can deposit the balance sale price in the court, and the court will direct the party either to register sale deed, or the court officer will come and execute the sale deed on behalf of the owner, through which you can secure your interest. As far as the seller is concerned, he may have to face some sort of difficulties in case the buyer is a crooked person. Suppose the buyer is a crooked person and pays small amount as an advance and did not come forward to pay the balance amount, then if that agreement is a registered one, the seller will face a lot of difficulties. The buyer is not coming forward to pay the balance price. Buyer is not paying the balance price, and if you go to sell the property to another person, the registrar will not permit you to register the sale deed. So under this circumstances, you will be in trouble. And if you go to the registrar office, the registrar will ask the seller to bring the agreement holder to come and execute the cancellation of sale agreement. So if you approach the agreement holder, he will demand some money. So the seller may have to face a lot of difficulties in case of the registration of the in case there was a registered sale agreement and the purchaser behaved in a crooked manner. So as far as the seller is concerned, if it is possible, you can insist the buyer to make the full amount and to go for a sale deed directly without any sale agreement. It is an advisable thing as far as the prevailing situation is concerned. As on today, there are a lot of politicians or crook people. Whenever there is a property, a prime property, they make small amount as advance and they get a sale agreement and register a sale agreement, and they do not come forward to pay the balance price, and they do not come forward to complete the sale, and through which they prevent the seller from selling the property to any other person. Thereby they demand some money for the cancellation of the sale agreement, through which they are trying to get unjust enrichment. So to avoid all these things, if the seller may insist the buyer to pay the entire sale price and to go and execute the sale deed instead of sale agreement. This is the advisable advice to the seller. In the present days, most of the people are paying a small amount from their own earnings, and they are approaching the bank for the major part of the investment. So as far as the bank is concerned, they will not release the loan amount unless there is some sale agreement. So what remedy is available? What should you do? So in order to overcome these things, you are advising the party to finalize everything. Before registration of the sale deed, you make an unregistered sale agreement and produce that unregistered sale agreement to the bank. Then they will immediately release the entire loan amount, through which you can avoid unnecessary distress. Suppose you can avoid unnecessary problems. So supposing the buyer is a genuine purchaser, he can tell the bank that the buyer is ready to execute the sale agreement, but not at this stage. Let us go through you may verify the title, you may verify value of the property, you may complete all your process, you may also sanction a loan. Before releasing the check amount, before releasing this loan amount, the purchaser will come and the seller will come and execute the unregistered sale agreement, and after receiving the sale agreement, you may release the loan amount. Like that, you can tell the bank is also accepting this type of arrangements. So this is the present situation. So simply saying sale, registration of the sale agreement is compulsory and it is advantageous to the purchaser. But as far as the seller is concerned, if the buyer is not a genuine person, you may have to face all these difficulties if he tries to cheat you or blackmail you through the crook methods. So I request all you to watch my channels. I have two channels. One is in English, that is raziaq lawtube. I have also one more channel, Tamil channel, raziaq Sattam Arivom. You can watch my channel and gain your knowledge. Knowledge is power. Legal knowledge not only will give you power, it will also develop your, it will also strengthen you with all sort of courage. So whenever you want to clarify any particular doubt, you can just type raziaq Sattam Arivom or raziaq lawtube in the Google Chrome. So my channel will open. There you can click my playlist. There are a lot of playlists. You can click the relevant playlist. From that playlist, you can choose any videos on the topic on which you want to clarify or you want to gain knowledge. That will help you to clarify your doubts and to enrich your knowledge. In addition to that, if you need any personal clarification, consultation, you may also contact my cell number. If it is possible, I will give you online consultation if the time so permits. Thank you. Goodbye. raziaq Ali.